Good morning, everyone. Welcome to our ESA webinar series. We'll wait a few more seconds and we'll get started. So just hang tight. Okay, welcome. For you that don't know, I'm Joe Schwanek, the Executive Director at the Environmental Services Association. Probably sick of getting tired of seeing my face. Today we have Sean Parker, who's a partner at McLennan Ross. He's also one of our newly elected board members. He'll be speaking to you for 40 to 45 minutes about inspections and investigations and what to do when the regulator comes knocking. And when we're done, we'll go back and we will do questions and answers. So I'll turn it over to Sean and then we'll go from there.
Sean? Thanks, Joe. Oh, thank you, Joe. So I just want to start out by saying I think this is a terrific initiative that ESA is undertaking here. Great way to stay connected with this webinar series, and thanks to Joe and ESA for having me here. I was talking with Joe the other day about this introduction and how this webinar was going to work, and he asked me, well, hey, you have any lawyer jokes? And maybe that's a good way to start. And everyone's got a lawyer joke. I'd like to say I've heard them all, but that's clearly impossible. Anyways, I figured we got enough ground that I want to cover today, so I'll run through the presentation, and then at the end we'll have some time for questions and maybe some bad lawyer jokes. So with that, we'll just jump in. I hope everyone can see my presentation here. So the first slide I've got up is just to give everyone an idea of where we're headed. Got an outline. So the title of this presentation is Inspections and Investigations. And as a starting point, it's important to understand that inspections and investigations are two distinct concepts. They're often discussed together and they're related, but they are different. So we'll talk about that, and then we'll run through some general principles, sort of the groundwork, the foundation for what we're going to be discussing, and then I've laid it out sort of on, how practically this information could be applied. So one is planning ahead. We'll talk about that because that's critical. Next, when the investigator arrives, so sort of the active on-site part of an inspection or an investigation. We'll talk about some things that may happen on site, seizing documents or information, potentially questioning witnesses, then what to do, after the active on-site part of the investigation. The investigation would still likely be open, so how to manage some of that, and then maybe we'll get into some questions. So my focus today is to give practical advice, or a practical overview, I should say, and some tips for how to be prepared and how to react if needed. I will introduce some legal concepts, and I have a few cases mentioned to provide some of the background and foundation for this information, but really my focus is trying to give some practical information here. I do also want to start out by saying that I'm providing general information in this presentation. Each situation will have its own considerations and circumstances, and accordingly, if you or your organization is faced with an inspection or an investigation, you should contact a lawyer for legal advice on your specific matter. So general principles. The starting point is really that a regulator or an investigator's powers are broad in regulated industries. It's essentially part of the trade-off. An organization or a person has permission to participate in the industry, and the flip side is that there's a decreased expectation of privacy and obligations to provide information and to cooperate. The duty to cooperate is a critical point, but the question is often, well, how far does that go? And again, an inspection, duty to cooperate in an inspection versus an investigation may be different, and we'll discuss that. There's also practical considerations about, aside from legal considerations on cooperation and the costs and benefits there. Advanced preparation is essential. I can't stress that enough. Reacting promptly and appropriately is important, and it's difficult to undo mistakes that may have happened at the outset. Get legal counsel and experts engaged early. This relates to things like maintaining legal privilege and preserving options and evidence for defenses should you need those down the road. It's important to know the agency or the inspector or the investigator is representing and the legislation that they're operating under, because all authority of the inspector or investigator, as well as the corresponding duties that the party under scrutiny has, that will all be grounded in the legislation. So that's something to understand at the outset. And then last, I have document it, because it's important to know what information has been provided and for you to be able to tell your story later on. So this slide that I have up here just has some of the what I've identified as key legislation that we see for inspections and investigations here in Alberta. My focus is on Alberta, but when we're in Alberta, there'll be both provincial legislation that would be an inspection or an investigation is carried on under, as well as federal legislation. So in terms of Alberta legislation, I've got the Environmental Protection and Enhancement Act, or EPA, and the Water Act, and those are administered by Alberta Environment and Parks or the Alberta Energy Regulator, depending on the nature of the work or the project. And then in terms of federal statutes, I just have some examples up here. The most common ones that we typically see: Fisheries Act, Migratory Birds Convention Act, and Canadian Environmental Protection Act, or CEPA. There's others as well. You know, Species at Risk Act is another one we sometimes see. And there's different federal entities that will administer those acts. Most commonly Environment and Climate Change Canada and the DFO, Department of Fisheries and Oceans. For example, they split enforcement of the Fisheries Act. So let's start off with talking about the difference between an inspection and investigation. As the slide here says, an inspection is to ensure or verify compliance with the legislation. An investigation, on the other hand, is to determine penal liability and to collect evidence when a perceived contravention has occurred. Okay, they're not the same thing. So just to reiterate that in different words, an inspection is used to verify compliance. An investigation is used to support enforcement action. Now, the difference is also important because, like I mentioned, the authorities that the regulator will have when conducting an inspection versus investigation may be different, and the corresponding obligations on the party being looked at may also be different. And again, it's all grounded in the legislation, so you have to, that's the starting point to see where there is. Now, oftentimes, an inspection will transition into an investigation. And sometimes that will be clear. There'll be a bright line. You know, there'll be a separate group that comes out, or you'll get a notice of investigation in the mail. But sometimes it's not. Sometimes there's a transition that's fluid. It happens on the fly, maybe. And the tipping point that has been clarified by the Supreme Court of Canada is when the predominant purpose of the regulator's inquiry goes to gather evidence of a potential violation, or to assess whether there has been a potential violation and to gather evidence to support that. When the predominant purpose shifts from verifying compliance to looking at penal liability. So I do have, here are the first two cases that I'm going to mention today. So these are both Supreme Court of Canada cases, Jarvis and Ling from 2002. They were what we call companion cases because they were The decisions were released at the same time. They dealt with similar issues. But I do want to start off by saying there's a lack of Alberta precedents. I'm not aware of any case law in Alberta discussing an environmental regulator's powers during an inspection versus an investigation under Alberta legislation. So I'm going to discuss these cases because they're helpful to set out some of the general principles. But again, the lack of precedents in Alberta has to be taken into account when relying on any of these cases from other jurisdictions. So essentially what Jarvis and Ling did is they stand for that proposition that an inquiry which commences an inspection will become an investigation when the predominant purpose is to assess penal liability. And this case is often cited by defense counsel in environmental regulatory matters. The prosecutors often discuss or cite a different case that I'll discuss in a few minutes. But just to give you the background of Jarvis and Ling, essentially, this is from a different regime. It's from tax regulatory regime. And what happened here is some individuals were subject to tax audits, which would be akin to like a routine inspection. And some irregularities were discovered. The regulators started digging deeper, and then investigators sought to use powers under the legislation to compel information pursuant to an inspection. So they tried to use inspection powers under the legislation to collect evidence in their investigation of these perceived contraventions. The Supreme Court confirmed that that was an improper use of powers. The regulator cannot use powers to compel information pursuant to an inspection for the purpose of collecting evidence in an investigation. So, like I said, that's helpful for sort of defining the general principle, but I know from discussions that I've had with prosecutors in Alberta over the years that they view the Jarvis and Ling decisions to be of limited application in Alberta because the legislation is different, and the powers of inspectors and investigators are often one and the same here in Alberta. So, for example, EPA Section 198 sets out an investigator's powers, and oftentimes, the investigator and the inspector is one and the same person. It's the same individual. They wear different hats depending on the circumstances, and the powers are generally the same. To contrast that, Jarvis and Ling was quite different in the sense that in the tax context, both the powers and the individuals of inspectors and investigators were quite different. So there was a whole group of people called inspectors, and they had a very defined set of powers under the legislation. And there was a separate group of people that were investigators, and they had another defined group of powers. So when the investigators started dipping in and using inspection powers, they clearly crossed the line. And that's why the court said that evidence, had to be thrown out, and it was an improper use of powers. In Alberta, it's not the same. It's not that clear, although that's going to have to be a subject for discussion of another day because it hasn't been litigated. Someday it will, but it hasn't yet. So I say this with caution that we have to be careful when we're relying on authorities or experiences from other jurisdictions. And I understand that some other Canadian jurisdictions like BC or Ontario have a division of inspector and investigator powers under environmental legislation that's maybe a little different or more clearly defined than in Alberta. But I did put up the golden rule here on this slide. Regulators cannot use inspection powers, which are for assuring compliance, to compel information to collect evidence during an inspection, an investigation. And then the next case I have up here is Nole. This is another Supreme Court case, this one from 2010. This is the one that prosecutors sometimes refer to. And essentially what happened in Nole is that an RCMP officer stopped a commercial tractor trailer and conducted a random search under Saskatchewan's Highways and Transportations Act. And in the course of that search, information of drug offenses was found. and ultimately tendered as evidence in support of criminal charges. In that case, the Supreme Court upheld the admissibility of that evidence. So this was a process that started as a regulatory inspection under provincial transportation legislation. And then when the information of an offense was discovered, the inspection transitioned to an investigation, and the evidence that was collected was ultimately upheld as being admissible. Now, prosecutors that I've discussed this case with say that this stands for the proposition that, you know, the distinction between an investigation and an inspection is really inconsequential so long as the investigating officer is acting within their prescribed legal authority. So in other words, whether what you call it an inspection or an investigation or when or how that transitions doesn't really matter so long as the regulator is acting within their scope of authority. And I see that perspective, I get it, but you know, I'm not convinced that it's that simple, and I'm not convinced that it's applicable under Alberta environmental legislation. Again, there's no case considering this in the environmental context in Alberta, so one day that will have to be litigated. What I have up here next is what's called the plain sight rule. I think this is an important practical piece of information. So it is a legal principle, and it's essentially what happened in Nole, where an inspector or an investigator can search and seize anything where an offense is immediately apparent. So, you know, I'll give you an example in the environmental context. A common situation might be where a regulator comes in for a routine inspection. They see evidence of a spill, for example, staining on the ground and a leaky hose, and then they proceed. At that point, they shift and proceed with an investigation of an unauthorized release and, you know, let's say potentially a failure to report. So in those circumstances, they would proceed with an investigation. It was immediately apparent that there was an issue here. They could take pictures, they could take a sample, and that information could be likely tendered as evidence in enforcement proceedings down the road. So this is an important concept, and we'll touch on that again later when we talk about what happens when the regulator is on site. Okay, so now let's get into talking a bit about you know, how to prepare for an investigation or an inspection. So I can't stress enough that it is critical to be prepared ahead of time. It helps to avoid missteps, and you want to ensure that you're ready to go, and everybody knows what the plan is ahead of time. It can be difficult to repair some issues or mistakes that happen early on in the process. And you know, I see a lot of companies have plans, emergency response plans for OHS matters or environmental matters. They don't always include discussion or protocols for dealing with the regulator and the investigator. So that's maybe something to look at your own organization and see what provision do you have for this, because it can really help you at the outset. So it's important to have a reporting structure and a chain of command. You know, we often say have a designated site coordinator, and so that would be a person to manage the flow of information. It should be a senior person with knowledge of the operation, maybe a site manager, someone like that. And they would be the point of contact to provide information to the inspector or investigator. Because what you want to do is you want to avoid having piecemeal information flow to the regulator in a haphazard fashion by numerous individuals. You know, you want to be organized. You want to know what was given to them. You want to have a clear understanding and record of that. It can be very problematic to give inconsistent information, even if done so innocently. Legal privilege is another concept that I have up here, because that's something you want to understand ahead of time, at least have a sense of it. So legal privilege is a concept where you know, information, you know, for example, documents or written communications may be protected from having to be disclosed to the regulator in the course of an investigation. And the basis would be that therefore obtaining legal advice or exercising one's rights to a defense. So a common example would be communications with a lawyer where legal advice is sought or requested. Now, just copying a lawyer on an email, whether it's an in-house lawyer or an external counsel, just copying them on a more routine email would not necessarily make that communication privilege. There are some nuances there, but something where that has some substantive legal content, a discussion or something prepared for the dominant purpose of litigation, those are privileged. And it's important to understand what privilege is, because you don't want to disclose information that you don't have to, that could potentially be harmful or incomplete or something to that effect. So it's important to have a sense of what that is. Planning ahead is also important to help your employees. In the heat of an investigation or an inspection or something, it can be a stressful thing for some people, and everyone is more comfortable when they know what to expect. There'll be fewer surprises and fewer slip-ups, hopefully, from that as well. So I've just got a few things listed here to maybe think about making employees aware of. People should be aware that they could be personally liable for offenses. Not trying to scare anyone, but if someone goes out, an individual does something clearly beyond their authority or scope, if there's some type of concealment or misinformation given, that clearly could give rise to personal liability. We don't see that often. It's quite rare. It's like I said, it's more in those cases of some kind of concealment or misrepresentation where we would see that, but it is possible. And there could be a conflict of interest between the individual and the company if those issues arise. No statement should be given until legal advice is sought. We'll talk about questioning witnesses later, but that's an important concept. Nobody is required to sign a statement that's written by an investigator. We see that not uncommonly, where someone will be speaking with an investigator, they want a statement, and the investigator says, well, I have one drafted here, why don't you sign this? You don't have to do that, and I would look at those very carefully before you consider doing that. And then this last bullet sort of touches on a potential conflict as well, because an employee with the duty to cooperate, they may have to give information, give evidence. They may be required to do that to support the Crown in some form of prosecution or enforcement, or for the company to support a defense. So everyone should know that it is a serious criminal offense to obstruct an investigation or to destroy evidence. These are serious standalone offenses. They could lead to criminal records in addition to any regulatory issues. It's probably the worst thing you could do, is mislead an investigator, give false information, destroy evidence. Those are really things that you should absolutely not do. A way to avoid destruction of evidence, whether it's innocent or intentional, oftentimes we see document retention protocols or litigation holds. So a notice could go out to the relevant individuals in an organization to say, there's legal proceedings here or likely to be commenced, and any information, documents, emails, anything related to this subject matter has to be saved and stored in a safe location. And you can go and collect those later on as well to maintain it. And there's a couple reasons for that. One is you want to be able to tell your story later. You want to have the information available. A request for information, and again, there's a duty to cooperate, and request for information may come at a later date, weeks or months down the road. You want to have that information available. And it prevents what's called spoliation of evidence. That's a legal concept where, let's say, for example, there's a piece of equipment that led to an incident, something failed, and the company may do their own investigation on it, and then they dispose of the piece of equipment before the regulator has had a time to inspect it and do their own assessment. Now, the mere fact that piece of evidence or information was destroyed or disposed of before the other side had an opportunity to look at it, means that that piece of evidence could be deemed to be harmful to your case, even if that's not the actual situation. So you want to prevent spoliation. So hang on to things. And again, I mentioned the duty to cooperate, and the legislation talks about things like reasonable assistance, relevant information reasonably required. So that is going to be a fact-specific assessment in a lot of cases. And again, you have to look at the legislation and maybe talk to your lawyer to decide what your obligations actually are. So when the investigator arrives on site, first thing first, deal with the emergencies. Make sure everyone is safe, stop the spill, protect the environment. That has to be done first. Next, I have up here, ensure the emergency numbers have been called, report it. Just because the regulator and investigator shows up on site doesn't mean that you don't have to report. Maybe they got a tip from a third party. Someone knows something happened, but it doesn't mean that the company has automatically fulfilled any reporting obligations. Failing to report is a standalone offense, and it's easy to prove. If you didn't report it, you didn't report it. So if someone shows up, if there's any doubt whether it's been properly reported, for example, there's the Alberta Environment 1-800 call-in number for a release, call it in. It's better to report it twice than not at all. Obtain the information of the investigator, understand if you're under an inspection or an investigation, what organization they're part of, get a copy, get a business card, copy it. You can ask, is this an inspection? Is this an investigation? What are you looking at? What legislation are you operating under? All that is going to be helpful when speaking with counsel and figuring out how to proceed. Also ensure that the inspector or investigator is wearing proper PPE and they can enter the site. You're going to be responsible for their safety while they're there to some extent. So make sure that that's all satisfactory. They may show up with some form of judicial order or a search warrant to seize things and inspect things. Have a good look at that. Make a copy of it and get it over to counsel. And then as well here, get legal counsel involved. Getting legal counsel and maybe some external experts involved in an early stage is often a good idea. It may put you in a better position to have a defense down the road. It might help you get started with some of those privileged considerations. As well, with an external expert, if you think you might need someone else, you want to get them on site so that they can see what the regulator is seeing, the investigators are seeing, before evidence is gone or the spill is cleaned up, depending on the circumstances. If you are clearly the subject of an investigation, the regulator is looking to collect evidence of penal consequences to support enforcement. In my view, it's totally reasonable to hit the pause button and say, we need to talk to our lawyer. Tell the regulator, say, can we just hold things in abeyance for a little bit here while we get hold of our lawyer, and maybe the lawyer can even come to the site, or after you've spoken with them, they can have a call with the investigator to talk about the ground rules. That to me is a reasonable request, and in my experience, the regulators are generally responsive to those. So during the active part of the on-site investigation, the on-site coordinator should accompany the investigator at all times. Take duplicate samples, take similar photos. Basically, you want to have a mirrored record of whatever they have, so you understand the information they're looking at and you have your own records of it. If the site coordinator needs help taking notes of what's being done or taking photos and samples, have a couple assistants with them. That's definitely acceptable. The next bullet I have, bring specifically requested materials to the investigator. So that ties into the plain sight rule that I mentioned. you know, it's an unfortunate situation if an inspector's on site to do one thing, and then you know, they're walking around and other issues are identified, and all of a sudden you're dealing with 3 or 4 problems instead of one. So if the site visit or tour can be organized in a more directed manner and avoid leading to creating greater problems, that's probably a good idea. So those are some practical considerations to keep in mind. Seizure of documents and information. So this is something we see from time to time. Certainly in recent years, we've seen this more with federal regulators, such as Environment Canada, as opposed to the Alberta regulators. But in Alberta, they have the powers to seek judicial orders and warrants as well. So, you know, we've seen a number of situations in recent years where the regulator will show up with a number of individuals at sometimes at more than one location, for example, a work site or a facility and a corporate office. They show up simultaneously, unannounced, with a search warrant in hand, listing a whole bunch of information that they want to seize, and this could include paper documents, computer hard drives, cloning cell phones, all those kind of things. If there is a search warrant or an order, I would say right away, contact your legal counsel, get them a copy of that warrant right away, scan it and email it to them. Because you're going to want to have a close look at that. That search warrant is going to define the bounds of what can be searched and seized. And you want to make sure that the warrant is executed in a proper fashion. You know, for example, no privileged information should be improperly divulged. So you're going to want to get counsel there, because determination of legal privilege is a legal issue that should be left to counsel. It certainly should not be something that is determined by the regulators reviewing the documents. I've seen that position taken in the past, and that's something that should be avoided. You know, you want to make sure that they're taking what they've sought the order for or obtained the order for, and not voluntarily divulging other information. Things that are voluntarily given can be very hard to retract at a later date. You know, having a search warrant doesn't necessarily allow them to go ahead and browse through all of the company's files. They're there for a reason. They shouldn't be given free rein to browse all paper or electronic files. And if there's a dispute over whether an item is privileged or not, the protocol is you take that item, whether it's a paper record or a USB stick or something, you put it in an envelope that gets sealed, and then a representative from the regulator, you know, one of the investigators, and a representative from the other side, the other party being looked at, maybe a lawyer or the site coordinator or someone like that, they both sign their name over the sealed part of the envelope. The envelope then goes to a neutral third party, often a clerk of the court, who holds it. And then, you know, if the parties can't sort out the privilege issue themselves or how to deal with it, a judge may decide how it's going to be handled. I'll also say that a party has a right to maintain their information for a couple reasons. One is to prepare a legal defense. Certainly you have a right to your documents and information to prepare your defense. And the other reason is, or another reason, is to carry out your normal business operations. You still have a right to that information for that purpose. So I would recommend that you always seek to retain the original documents of anything that's seized, if the investigators will take a copy. That's not always feasible. In that situation, you certainly want to take a copy yourself of anything that's taken away, because you might not see it for quite some time. I would also recommend having a detailed list of everything that was seized. The investigator will be required to give a receipt or an inventory of what was seized, but in my experience, those descriptions aren't always very detailed, and they might not be meaningful to the party that had the information seized. It might not be meaningful to actually understand what was taken. So something else that'll happen on site, or maybe not on site, but during the active part of the investigation is questioning of witnesses, or at least the regulator seeking to do that. So again, there's this general duty to cooperate, provide reasonable assistance or relevant information, or information that is reasonably requested. Different legislation has different requirements there. Those are sort of the general concepts that are common amongst most of the legislation. But what will be reasonable in a particular circumstance, may be fact specific. And I'm going to start off by saying that the regulator or the investigator's ability to compel witness statements in the course of an investigation will depend on the specific wording of the legislation. So before anyone gives a statement, it's advisable, to understand what those powers are and maybe seek counsel. There's some debate currently in Alberta as to the extent of regulators' powers to compel statements in the course of an investigation. For example, in EPEA, there's some express provisions about questioning witnesses, but it's not clear if that's in an investigation or just limited to an inspection and how far those powers go. And again, it has not yet been judicially considered. There's been no cases in Alberta about that. On the other hand, the Water Act in Alberta has the provision there a little different, and in my view, a little more clear on the extent of the investigator's powers. So there are those important legal considerations. But in addition to the legal considerations, there's also practical considerations, and these are important. There may be some debate or a lack of clarity on exactly whether someone is required to give a statement or not, or even if it's clear that you think that they don't have to. Parties will often choose to voluntarily provide those witness statements. There can sometimes be a lot of benefit gained from cooperating. It can help maintain a positive relationship with the regulator. I mean, some of these, sometimes you're dealing with the regulator on a regular basis, and you want to maintain a positive relationship and credibility with them. You want to avoid getting entangled in an adversarial process that would inflame the situation. On the other hand, if you're being treated, if the impression is that you're being treated aggressively, for example, with unannounced search warrants, then people often respond in a more guarded fashion, and maybe you'd be a little more careful in those circumstances. Again, it's going to be a cost benefit, and you're going to have to weigh the circumstances and where you think it may go. You certainly want to avoid any obstructive conduct or perception that you're not being forthright. That's critical. You want to be forthright. You want to have clean hands. You want to fulfill your duty to cooperate. And you may, another practical benefit is you want to maybe tell your side of the story early on and avoid having the regulator with an incomplete picture and proceeding down a route that turns out to be problematic or at least difficult to get back on track from your perspective. With interviews, on the slide here, I have up a couple bullet points I'll just mention. So oftentimes the interview will be set in for a future date. The investigator, wants to get prepared. They're going to want to digest some of the information, figure out who to witness or which witnesses to question rather. So you might get a list of people they want to witness, they want to question, and set some dates for a couple weeks down the road. That is good for the company as well. It would give you time to retain counsel, prepare the witnesses so they know what to expect. Sometimes there'll be more than one government agency investigating at a time. For example, if there's a release into a water body, you may have AEP or the AER investigating. You may also have DFO or Environment Canada. So coordinating, having one set of interviews with both regulators present is something we often like to do. And this last bullet is a critical one as well. If you get a warning that information may be used against you, heed that warning. it's true. They're there for a purpose, and in my experience, the regulators or investigators are generally very professional, and they're there to do a job, and they'll give you these warnings in a very matter-of-fact manner. It's not going to be dramatic necessarily, but that doesn't mean it's not important. So in terms of actually questioning a witness, it's important to understand what the purpose is. The purpose is for that witness to give factual information. They are not there to give opinions on what could have happened or what may have gone wrong. They're there to speak to the facts as they know them within their personal knowledge. A witness should never guess or speculate. That's not going to help anyone. I say have a lawyer present here. So there's different schools of thought here depending on the circumstances. Sometimes, again, parties will want to keep the temperature down and won't want to have a lawyer present. In my experience, investigators are not surprised when there's an investigation and the party under investigation wants a lawyer there for the examination. It's a right they have, and it's quite commonly done. A lawyer can help keep the interview on track. There is a limited ability to intervene for the lawyer to intervene, because there is, the regulator does have broad powers in that regard. But I've seen instances where the investigator, whether intentionally or not, does ask inappropriate questions. They're asking for opinion evidence, or they put a document, maybe a document that was created by someone other than the company, a totally new document that the witness has never seen, and they want to ask questions on interpreting some document they didn't prepare that they've never seen. Well, maybe that's not appropriate either. So you can try to get things back on course, and as long as everyone's professional, as would be expected, then there shouldn't be any issues from my perspective. I will say, though, that there are some different practices amongst different regulators, and we have had some circumstances with some regulators operating under some legislation that don't allow counsel to be present. So that's another thing to consider. It is important for employees to know that the statements they give may be used against the company. They could face personal liability, like I mentioned before, depending on what comes out of the interview. Again, if there's any kind of concealment or misinformation, that's serious. They don't need to sign statements. I've said that before. And then there's this thing called a caution statement, which should automatically set off alarm bells in everyone's head. So sometimes either at the beginning of an interview or at some point in the interview, the investigator will give what they call a caution statement, which is essentially a warning under the Canadian Charter of Rights and Freedoms. And what that should do is that again sets off alarm bells. That means that the regulators are looking at personal liability for that individual. So this would be similar to you see in TV or on the movies, you have a right to remain silent, you have a right to an attorney. If you cannot afford one will be provided, blah, blah, blah. So those are Miranda rights in the United States. We have something similar in Canada. If you get a warning like that, if an individual gets a warning like that, they are being looked at for personal liability. Now, that engages charter rights, and oftentimes in that situation, an employee, or rather the witness, the individual will choose to shut down the interview, because the charter provides you with a right that you do not have to give self-incriminating evidence. So oftentimes they'll choose to shut it down. Corporations have different rights, or generally not as extensive rights under the charter. So we don't see caution statements given for corporations, but they are for individuals. So I just want to highlight that because that is a critical point. And if an employee or someone does get a caution statement, they may want to get independent legal advice, get an independent lawyer. Often we see that the company will want to pay for the lawyer to support the employee and maintain that relationship, but their individual rights may be different. There could potentially be a conflict of interest with the company, and that should be something that is considered. I also have make a recording up here as something I suggest, because if it's feasible, you want to seek to have that, the investigator will make a recording almost certainly, and you might want to have one for your records as well to understand what was said, and you may want to have that, going into the future if it's possible, if everyone agrees. I've never had anyone, a regulator, say no. So after the investigator leaves the site, so I had talked about the active part of the on-site investigation. So in investigations, often what happens is there's an initial flurry of activity. There's the on-site visit. Maybe there's some follow-up in the, in the weeks after, and then there might be a lull where the investigators are digesting the information, reviewing things. That doesn't mean that the investigation has gone away. Sometimes they linger for some time. It could be weeks or months down the road before you get a request for more documents or to interview witnesses. And even then, after witnesses, there might be, depending on what information comes out there, a request for a second round or more information. So it's advisable that the coordinator or the legal counsel maintain contact with the investigator, whoever's going to be the face of that. You should meet with your legal counsel, take stock of what happened and where you're likely going, and have a plan. You want to preserve evidence, like we talked about before. You also can maybe anticipate if there are going to be some document or information requests coming out, what they might ask for, and assemble that information so you can respond quickly and appropriately, so you're not doing it in a rushed fashion. And you want to document your improvements. This is also important because although you can't reconstruct a due diligence defense, so after the incidents happen, steps you've taken afterwards aren't going to help you to say you were duly diligent. You can't reconstruct it afterwards. But a lot of times after an incident, a company will learn from that and they'll take steps to improve their operations and their practices. And it's very important to document all that because that may help when you can demonstrate, all the great work you've done and why this isn't the steps you've taken to ensure that similar incidents aren't going to happen. That may influence the enforcement action taken against the company. And if it's in a prosecution, it'll be a sentencing factor that the court would consider. So I just have on this slide here some potential enforcement actions that you may expect. Well, I guess first of all, nothing might happen. There may be no action depending on what comes out of the investigation. Warning letter, that's sort of the lowest level. Administrative penalty is like an administrative fine. Enforcement order, EPOs, those can be onerous. You can appeal those as well. You can appeal an administrative penalty, and the timelines for appealing some of these are very short. So if you have an issue with it, you might want to talk to a lawyer right away. And then prosecutions, again, against corporations or individuals, the most severe form of enforcement action, and those can be very time-consuming, costly, and may result in bad publicity as well. So that's pretty much what I wanted to talk to everyone about today. And with that, I will turn it back over to Joe for any questions or bad lawyer jokes.
Thanks, Sean. That was great, and there's a lot of information in there for us to digest. So if people have questions, you can type them in, and I'll try to get through in the remaining 15 minutes we have as many as I can. Where do we start? Should we welcome inspections without prior notice?
Well, I don't know what you mean by welcoming inspections without prior notice. Of course, you would rather have notice, I think, is typically what people would want, but they don't have to give you notice, strictly speaking. Again, it depends on the legislation they're operating under. But if somebody shows up, if an inspector shows up unannounced for a routine inspection, the company's ability to object to that is likely going to be very limited. They probably have a right to be there. If you have any questions about that, you can reach out to a lawyer because every situation is going to be different, and you have to look at the legislation and the approval. If you have any approval or authorization for your facility, for example, that would be the starting place to look. but quite typically, a routine inspection is one of the obligations you may have as participating in a regulated industry.
Okay. Can you refuse access to a regulator without proper safety tickets and/or PPE?
That's a good question. And again, you know, I hate to sound too much like a lawyer. Every situation is going to be different. So, you know, I can give some general comments on that. If they don't have the right PPE to be there, then they can't go in. Now, can you withhold PPE from them? Probably not. If they want to be there and they don't have it, yeah, maybe you can send them away and tell them to get it. I would anticipate they show up again a little bit angry with the proper PPE, so maybe you can help them get it. You know, again, every situation is going to be different. In terms of safety tickets, you know, that's a good question. And, you know, for example, if someone wants to go into a confined space, which just sort of jumps out at me, you know, they'd have to follow the proper protocols. And I would think that some inspectors do have a lot of those safety tickets. I don't know. You know, again, that would be something though that I would raise with them at the beginning and in a forthright and professional manner. And we've got these safety concerns. If you can't, you know, demonstrate and satisfy us that that you have the appropriate training and equipment to do that, we're not going to let you in. And if, you know, and if there's an issue there, again, you know, they can speak to your lawyer if that becomes an issue.
Okay. At what point of an investigation does the regulator need a search warrant, and what evidence can be used in court without a search warrant?
Well, that's a complicated question. You know, so I can tell you some basic principles. One is the plain sight rule. If something's in plain sight, you don't need a search warrant for that. And again, that would extend to anything that's immediately apparent. If there's a document lying on a desk, sitting on a desk, and they can see it and read it, that's in plain sight. If there's evidence of a spill on the ground, they can go and collect a sample. That's plain sight. Those things would all be admissible. Sorry, Joe, could you reread that question again? There was a second part to it.
I deleted it. What was the, sorry.
Okay, no, that's fine.
In court and
okay, I know what I was going to say.
Search warrant.
Yeah, sorry to put you on the spot there. The other part of that is there's a duty to cooperate. So, you know, generally any document that is created in the ordinary course of business is going to be producible. If it's a part of your ordinary operations, you know, this is getting into, again, inspections versus investigations. You know, if you've got an obligation to maintain certain documents as part of your approval, for example, certain water, air quality monitoring data, for example, and that's part of your approval requirements, you know, there's going to be very limited abilities to resist providing that information. You know, other examples would be like text messages on a cell phone. That is something that clearly, you know, maybe not clearly, but in most circumstances, that would be something where you would need a search warrant. That's not necessarily in the ordinary course of business. It's a device that might be used for personal use, those types of things. So if there's any questions or issues with that, you know, again, you may have to reach out to a lawyer.
Sorry about that. How long do regulators have to bring charges?
Oh, that's a good question too. Well, that depends on the piece of legislation they're operating under. Most Alberta legislation is 2 years from when it came to the attention of the director that there was some type of contravention. So when the clock starts ticking is also fact specific. You know, it might be at some point when they get a piece of information that they're going to rely on. They say, well, this was the tipping point when we knew there was a contravention. So generally 2 years to lay charges. That's to lay charges, and then prosecution itself is a whole other thing with timelines. That's for some offenses. that's generally what we see under Alberta legislation. Federal legislation is a little different. I believe under the Fisheries Act, I'm just going off the cuff here, but I believe it's 5 years for what they call a summary conviction offense, which is like a misdemeanor, sort of a lower level of offense. For an indictable offense, I believe there is no limitation period. So the limitation periods, that's what we call limitation periods, the time that you have before you have to bring an action. That depends on the legislation, the statute that it would be under, and also when that clock starts ticking will depend on what information is being relied upon as well.
Okay, is there a requirement to notify when an inspection has transitioned to an investigation, like sending out a notice of investigation?
Generally, no. Again, some legislation may have specific requirements, but for example, under EPA, no, there is not. It depends. The regulators have different practices of when they'll do that, but quite often you do see a notice of investigation, and that's obviously a clear demarcation, but not necessarily. Like sometimes it happens fluidly on the fly in the middle of an inspection. There's evidence, or there's plain sight rule. You see a spill, and it looks like it's a contravention, and it's bad. It could transition into an investigation right there on the spot.
Okay, just so everyone knows, yes, there'll be a copy of the presentation available later. I'll get it from Sean and we'll post it as a PDF. Certain inspectors carry guns. On a plant site, what that introduces an ignition hazard, what are we allowed to ask them to do?
Well, that's a good question. I don't think I've ever had that specific issue to deal with. Yeah, some do carry guns. I think that, you tell them that we've got an ignition hazard and it's not safe to have a gun, and you can come back at another time when you don't have your gun, go store it properly, because I don't know if you want to be responsible for storing your firearm either. I think that would be my gut reaction to it.
Okay. There's a comment about slide 10, which is the Environmental Appeals Board and Public Land Boards seeing cases where individuals are being named in administrative penalties along with the company. Mm-hmm. There's no question. I think it was just a comment. So.
Yeah, there are sometimes individuals. I think actually the biggest, we've seen an uptick in administrative penalties in the last few years. I'll just take this opportunity to comment. The regulators have been, Alberta Environment and Parks in particular, I've seen there's this provision where they can add what they call an economic benefit component to the penalty. So if they derive, if the offender derives an economic benefit, they save some money, or they get some economic benefit from the contravention, then that money can all be disgorged from them. And there was a very high one, I think it's called Alberta Reclaim, where there was a scheme under beverage container recycling, and that was into the hundreds of thousands of dollars. And that was appealed to the Environmental Appeals Board. The Environmental Appeals Board found a calculation error and actually increased the penalty. It was several hundreds of thousands of dollars. Yeah, so we do see that.
Okay. 3 left. I'll try to get through them quickly. Is anyone lobbying to change the legislation to make the difference between inspections and investigations more distinct?
I'm not aware of anyone lobbying the legislature to do that. I'm not aware. I think that eventually it's going to get litigated, and we'll probably have to wait until that point. Okay.
For some regulatory inspections, the inspectors require you to submit a substantial documentation prior to the site visit, essentially a focused audit. Then when evaluate your site facility based on documentations and observations, what is your recommendation for minimizing the investigation component enforcement for these types of situations?
Well, I think first of all, you have to see what the request is. Is it, appropriate? Are you required to give that information? If, again, there's ordinary business records that you would be required to keep under your approval, for example. This sounds like the type of question for a significant facility that would have an operating approval. So that's my assumption here. You look at, are you required to give that information, and then assemble it in the most reasonable and organized fashion and give it to them. There may be some debate whether you're required to prepare new documents or just submit documents that you already have in existence. Again, this will be one of those balancing things where you want to deliver the information as organized and reasonably as you can in order to give the regulator a clear picture without, maybe volunteering extraneous information. So a balance of what are you obliged to do, the benefits of cooperating, and keeping everything organized. My advice would be, again, examine, or on this generic scenario, my recommendation would generally be see what information you're obliged to give, make an assessment there, and then provide it in the most organized way you can.
Okay, this is a big one. It's a three-parter, so hopefully we can get this. If the organization you are employed by, i.e. local government, has been issued a notice of investigation and you have been asked to be interviewed first, are you required to attend the interview and give a statement? Is there a difference between AEP or Environment Canada DFO authorities to compel an individual to give a statement? And instead of attending the interview, could you give a written statement?
That is a big question. I'll start off by saying that sounds like it relates to a specific matter.
Yeah.
So I think that you'd have to talk to your lawyer in terms of, general implications there. Regulators.
How about are you required to attend, or can you give a written?
Again, this is, first of all, you're going to have to look at the legislation. What does it say? That's going to ground and inform whatever obligations you have and what authorities the investigator has to demand information. Some legislation talks about questioning witnesses. That seems pretty clear that oral statements will have to be given. Some legislation expressly says oral statements. If they make reasonable requests orally, then you might have to give a response orally. You can ask to provide it in writing. If the regulator accepts that, then fine, you can do that, but they might not, and they might have authority to do that. In some situations, maybe they don't. And it's going to be one of those, give and take cost-benefit analysis we talked about, whether you want to cooperate or not. And again, it's not so much what powers each regulator has, it's more what is prescribed in the legislation that regulator is trying to enforce in that matter. So maybe the answer to all three is maybe.
Fair.
Did I answer the questions?
I think so. Yeah. Okay. Yeah, one last one that just came in. Are Alberta appeal board decisions considered precedent, and is there a process to appeal their decisions?
Good question. So they are not technically legally binding on actually on other tribunals or courts. So the Environmental Appeals Board is what we call an administrative tribunal. They are an expert tribunal made up of technical subject matter experts as well as lawyers and legal experts. Their decisions are not technically legally binding on the courts or on the appeals board itself. That being said, they are generally regarded as highly persuasive. So what I mean by that is if the Environmental Appeals Board, they're established as an expert tribunal to make decisions on technical environmental matters and matters of environmental policy within the province. They were established by the legislature to do that. A judge is going to be reluctant to interfere with technical decision on environmental policy and technical matters that was decided by an expert tribunal. In terms of the process for appealing it, different matters, it depends on the type of decision that they issue as well. Some decisions are final as stated in the legislation, and some can be taken for what's called judicial review, where the court would not necessarily impose its own decision, but if they thought an error was made in the board's process or decision, then they could explain that problem and remit it back to the board. I would also say that depending on the type of decision and matter decided, it's actually technically not the Environmental Appeals Board that makes the decision. They issue a report and recommendations to the Minister of Environment, who then ultimately issues a ministerial order, either adopting or modifying or rejecting the board's report and recommendations. Oftentimes they accept it. So it's a bit of a roundabout answer, not technically binding legally, although highly persuasive, and there's different types of decisions that will have different mechanisms and abilities to challenge them under the legislation.
Great. Thanks, Sean, and thanks, McLennan and Ross. If anyone has any topics you think would be of interest to a large mass of people, please drop me an email, or if you're interested in sponsoring any of these, I'd appreciate it as well. Thank you again, Sean, and thanks everyone, and we'll talk to everyone next week. Take care.
Thanks, Joe.